Welcome to the 41st lecture of this lecture series on International Arbitration Practice. This lecture is a part of Chapter 3 on Responding to Notice Invoking Arbitration and Defenses. In the last 6 lectures, we discussed the defenses of host states in international arbitration. These lectures acted as a prelude to the discussion on replying to the notice of arbitration, which is the subject of the present lecture. In international investment law, a notice of dispute is provided so that the investor invokes the treaty and a chance is given to make genuine attempts to resolving the dispute with the host state. If it is not settled, then notice of arbitration is given. By the time, the host state would have already taken a decision to amicably resolve the dispute or not to. A notice of arbitration conveys the serious intent of the investor to invoke the dispute settlement procedure of the investment treaty. The response to the notice of arbitration conveys the host state's defenses and is a chance to let the investor know that her case lacks merit. It is through the notice and the response to the notice of arbitration that steps are taken to constitute the tribunal. Hence, reply to the notice of arbitration is to be given by the host state. Before we go into drafting a reply to the notice of arbitration, let us look at the procedural rules relating to it. Article 4 of the International Arbitration Rules 2020 as amended provides for response to notice of arbitration. Article 4.1 states that the respondent, which is the host state, is to send the response to the notice of arbitration within 30 days of the receipt of the notice of arbitration. Article 4.1 also lists the essential items of a response to notice of arbitration. A. The name and contact details of each respondent, and B. A response to the information set forth in the notice of arbitration pursuant to Article 3, paragraphs 3C to G. The information set forth in International Arbitration Rules in Article 3C to G are C. Identification of the arbitration agreement that is involved. D. The identification of any contract or other legal instrument out of or in relation to which the dispute arises, or in the absence of such contract or instrument, a brief description of the relevant relationship. E. A brief description of the claim and an indication of the amount involved, if any. F. The relief or remedies sought. G. A proposal as to the number of arbitrators, language, and place of arbitration if the parties have not previously agreed thereon. So, the response to the notice of arbitration is to respond on each of these aspects covered in the notice of arbitration. There are additional elements of a response notice. These are captured in Article 4.2 of the International Arbitration Rules. A. Any plea that an arbitral tribunal to be constituted under these rules lacks jurisdiction. B. A proposal for the designation of an appointing authority referred to in Article 6, paragraph 1. C. A proposal for the appointment of a sole arbitrator referred to in Article 8, paragraph 1. D. Notification of the appointment of an arbitrator referred to in Article 9 or 10. E. A brief description of counterclaims or claims for the purpose of a set-off, if any, including, where relevant, an indication of the amounts involved and the relief or remedies sought. F. A notice of arbitration in accordance with Article 3 in case the respondent formulates a claim against a party to the arbitration agreement other than the claimant. Note that 4.2a deals with jurisdictional objections while 4.2e concerns counterclaims. Both should not defeat each other. The respondent should be careful in dealing with this. The respondent should not raise jurisdictional objections on the one hand, but raise counterclaims that may equally be subject to the same jurisdictional objections. As stated in the beginning of this lecture, it is through the mechanism of notice of arbitration and the response to the notice of arbitration that significant steps are taken to constitute the arbitral tribunal. Hence, it is important for host states to respond to the notice of arbitration. This is why Article 4.3 of the Unsettled Arbitration Rules states 3. The constitution of the arbitral tribunal shall not be hindered by any controversy with respect to the respondent's failure to communicate a response to the notice of arbitration or an incomplete or late response to the notice of arbitration, which shall finally be resolved by the arbitral tribunal. For investment treaties that were concluded prior to 2010 and which provides for ad hoc arbitration under the Unsettled Arbitration Rules as the rules applicable to arbitration, as opposed to the institutional arbitration such as through ICSID, the Stockholm Chambers of Commerce or the International Chambers of Commerce, there is a controversy as to whether the Unsettled Arbitration Rules 2010 is applicable or its previous version, the Unsettled Arbitration Rules 1976 is applicable. There is also an interesting aspect. If you go through cases in international investment law under the 1976 version of the Unsettled Arbitration Rules, you will hardly find cases which have a response to notice of arbitration. Whereas under the 2010 version of the rules, there is Article 4 on response to notice of arbitration after Article 3. In the 1976 rules, there was no provision equivalent to the present Article 4. This probably explains why one could hardly find any international investment cases under the Unsettled Arbitration Rules 1976 where response to notice of arbitration was issued by the respondent. In other words, the concept of response to the notice of arbitration was not contemplated explicitly under the 1976 arbitration rules. In the next lecture, let us build a checklist of items to be included in a response to notice of arbitration. But in this lecture, let us also see a sample reply from an actual case. Nord Stream 2 AG versus European Union, PCA case number 2027. A case initiated under the Energy Charter Treaty where the applicable rules of arbitration are the unsettled rules. The notice of arbitration was dated 26 September 2019. The reply to the notice was dated 24 October 2019. Look at the structure of the reply. Broadly, the structure is like this. The response starts off with an introduction, then it recounts the procedural history, then moves on to procedural matters such as appointment of arbitrators, appointing authority, seat of arbitration, etc. The fourth part is jurisdiction, which is a prelude to the jurisdictional defenses that EU would take. The fifth part is the denial of breach of the Energy Charter Treaty or of the rights of the claimant. The sixth part relates to relief and damages. From the table of contents, we are able to understand the main contents of the reply. Just now, we spoke about two versions of the Unsettled Arbitration Rules being applicable. The 1976 rules and the 2010 version of it. In this reply, this aspect is also addressed in para 4, which you can see in front of your screen. Let me read para 4 for your convenience. 4. The claimant purported to file its notice of arbitration under the Unsettled Arbitration Rules 1976, the 1976 rules. The 1976 rules do not provide for the filing of a response. The EU therefore files its response without prejudice to the question whether the 1976 rules or the 2010 Unsettled Arbitration Rules appropriately apply to investment arbitration proceedings currently initiated under the Energy Charter Treaty. From this, we understand that the claimant filed a notice under the 1976 version which did not rightly contemplate a response to the notice. Since the applicability of the version of the unsettled rules is a contestable matter, EU did the right thing by reserving its right to raise the point and issue the response without prejudice to addressing the question of applicability later. Makes a lot of sense. We will have a look at the remaining portion of the response in another lecture. Till then, bye bye and stay safe.